All right, we're here this afternoon on a preliminary hearing accompanied by a request for removal. May I have the, oh no, I'm sorry, this is for in-home jurisdiction. I said corrected. May I have the names of our participants, please?
Your Honor, I believe it is for removal for one parent and in-home for the other, just for clarification. Nicole Underwood, guardian ad litem for the minors.
Ms. Saja Thomas, counsel for the department.
Rachel Wazik, CPS investigator for the department.
Please spell your name, please.
Michael Brooks. I represent the mother, Melissa Gabriel.
Okay, hang on 1 second, Mr. Brooks. I need Ms. Our CPS investigator to give us her spelling of her name.
Rachel, and then the last name is Waczczyk.
I didn't see her over there.
It's okay. Go ahead.
Michael Brooks. I represent Melissa Gabriel, the children's mother.
Melissa Gabriel, I'm the mother of the children.
Thank you.
Alexis Stang, attorney for respondent father, Joshua Esterline.
Joshua Esterline, father.
Very good. All right. We do have one, as Ms. Underwood articulated, one non-respondent parent, Mr. Christopher Kassar. Do we have that person with us as well?
Yes, I'm here, Your Honor.
Okay, welcome. Thank you for coming. All right. Well, at a preliminary hearing accompanied by a request for removal, in which in this case there is one, and in another, the case of the other child, there is a request for in-home jurisdiction. Respondent parents have a number of rights, and so I'm going to go over those with you, specifically Mr. Esterline and Ms. Gabriel, before we get started. But I may have some questions for you, such as did you receive the petition, and some other preliminary things that I'm going to go through with you. Which means that we'll need to have you under oath. So Mr. Joshua Esterline and Melissa Gabriel, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, sir.
Thank you. Did you have a question, Ms. Stang?
Miss Underwood dropped off, it looks like. I just wanted to let you know.
She's actually logged in. She's just not, she's just turned her video off.
Got it. Okay. I just wanted to make sure she was still there.
Yes. The only way you can see a participant in the courtroom is if they have their video on.
Got it.
Okay. All right. So as to our respondent parents, Mr. Esterline and Ms. Gabriel, you both have the right to an attorney, which is why one has been provided for you today through the Public Defender's Office. You're welcome to retain your own attorney. That person would have to contact your current attorney and get the information from them if you decide you want to hire a different lawyer. You have the right to admit or deny all of the allegations in the petition today. You have the right to have me read that to you in its entirety also. Many parents choose to waive that, but I would be happy to read it for you if you need it. It appears to be a 6-page addendum to the form itself, and that's what I'm talking about when I say you have the right to have me read that to you out loud. Hopefully you've each received a copy and you've had a chance to go over that with your attorney. Ms. Gabriel, have you received a copy of the petition?
I have.
And have you had a chance to talk with Mr. Brooks?
Briefly.
Okay.
Very briefly.
Very fair. Mr. Esterline, do you have a copy of the petition?
Yes, I do.
Very good. You've had a chance to talk with your attorney?
Yes, I have.
Very good. All right. Both of you have the right to seek placement of your child during today's hearing. As articulated by Ms. Underwood, there's a request for one of the children to be placed in foster care and the other to be placed, I think, with Mr. Kassar, who's a non-respondent parent. So you have a right to be heard on those requests by the department, and the department will have a chance to show the court why removal may be necessary at the time. But that's what's on the table today, and you have the right to seek placement. All right, Mr. Esterline, do you know if you have any reason to believe that you may be a member in a Native American tribe or band, or have any eligibility for any Native American tribe or band?
No.
Same question for you, Ms. Gabriel. Are you a member of any tribe, or eligible for membership in any tribe, if you know?
No, ma'am.
Okay, thank you for confirming. It looks like there may be a support case as it relates to both of these children, Ms. Gabriel. Is that correct?
Yes.
Are there any other cases that you know of, like guardianship or delinquency or anything else that would concern either of these children?
No.
Okay, Mr. Esterline, other than the potential support case about your child, are you aware of any other cases?
No.
I'm sorry?
No.
Okay, thank you. All right. Ms. Gabriel, would you like to have the petition read or would you like to waive that?
I'll waive that.
Mr. Esterline, would you like to have the petition waived or would you like to waive that?
I'd like to waive.
Thank you. All right. All right, so the other thing I have to decide today is whether or not there's probable cause that one or more of the allegations in the petition are true and fall within MCL 712A.2b. In the petition itself, it tells you what the court's going to be looking for, essentially whether or not there's a substantial risk of harm to the child in the care of you as a parent right now, and whether or not it would be potentially an unfit place for the child to live, requiring the court to decide if removal is necessary. So that's what we're looking at today, is whether or not the petition should go forward and whether or not your children should be removed from your care. At this time, are there any preliminary questions or issues before we go forward?
I just want to
Yeah,
clarify that I believe,
We might
sorry,
be saying, but I just want to clarify, our relief requested, Your Honor, the older child is Mr. Esterline's child, and we are just asking for in-home jurisdiction with him. And then the youngest child, Mr. Kassar has not established paternity, and so we are just requesting DNA to establish legal paternity for the youngest child, but that would be the child who would effectively need removal.
Has that happened yet, DNA?
No, we are requesting an order so that we can get that done.
Do you have reasonable cause to believe that Mr. Kassar is the parent of the child?
It's my understanding that Ms. Gabriel has reported that to the CPS investigator.
All right. And has Mr. Kassar been advised then that he may potentially be a placement for this child as a result of that?
Yes.
Okay. I'm sure I'll hear more about that in a few minutes. Okay. Ms.
I was going to say the same thing. I just wanted to clarify that it was in-home jurisdiction that was requested for my client.
Very good. Do you know how your client would like to proceed as it relates to the petition?
Yes, he would like to stipulate as to probable cause.
Very well. Does he wish to ask the court to schedule a trial on the case or enter a plea?
He would like to enter a plea.
Thank you. Mr. Brooks?
My client wants a jury trial.
Very good. We can look for some time for that on the docket as well. Ms. Thomas, do you have a preference as to whether or not we take Mr. Esterline's plea first, or if we talk about removal, placement, and authorization of the petition first?
I don't have a preference, Your Honor.
Okay. Ms. Stang, any preference?
I don't have a preference.
Mr. Brooks?
Whatever suits the court.
All right, Ms. Underwood, any preference?
No, Your Honor, thank you.
Would you find it to be in the best interest of his child for me to accept Mr. Esterline's plea?
Yes, Your Honor.
All right, so let's begin there. All right, Mr. Esterline. Is it true that you wish to essentially admit what's happening in the petition?
Yes.
All right, if you do that, you're entering a plea. If you enter a plea, you're giving up your right to a trial by judge or trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses appear and testify under oath at trial. The right to cross-examine those witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I just indicated to you if you admit to the allegations in the petition and enter a plea?
Yes.
Okay. With regard to the consequences of your plea, or in other words, what would happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment assessments, or parenting classes. If it appears that you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. With regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Mr. Esterline, do you understand the consequences of your plea?
Yes.
Do you have any questions about any of the information I've given you so far?
No.
Very good. Ms. are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this afternoon?
No.
Is anyone making you enter a plea or admit to the petition allegations?
No.
Has anyone threatened you in order to get you to enter a plea?
No.
Has anyone promised you anything in order to get you to enter a plea?
No.
Would you say your decision to enter a plea is one you've made of your own free will?
Yes.
Thank you. All right, Ms. Stang, maybe you could answer this one a little better if you wish. What are the main reasons that were articulated in the petition that you believe would support your client's plea?
So it was stated that there was a prior CPS investigation, and it sounds like Wood County was also involved in that, where his current wife was living in the home and caused some bruising on Jaden's body after Josh had entered into a safety plan saying he wouldn't allow his current wife, which is Daisy, to be around Jaden or in the home, which then occurred. So that's the basis.
All right, are there specific allegations in the petition you'd like me to review, or are you considering the plea essentially to allow me to consider all of the allegations in the petition?
It would be all of the allegations in the petition.
Very well, thank you. All right, presentation of anything in particular, Ms. Thomas?
Your Honor, if you would like me to move forward with the probable cause hearing as relates to mother, I would call, and Rachel, I'm going to butcher your last name, Miss Wasick, maybe.
All right. That would be fine, because I think many of the things discussed as it relates to Mr. Esterline are probably also going to be relevant as it relates to Ms. Gabriel's decision to contest the removal. Any objection, Mr. Brooks?
No.
Ms. Stang?
No.
Ms. Underwood?
No, Your Honor.
Very good. All right. Ms. CPS Investigator, who's going to remind us how to pronounce your name in a moment, come on up to our witness stand.
Thank you, Your Honor.
Okay. Proceed at will.
Thank you. Ms. Wasick, for the record, can you please articulate how you are familiar with this matter?
This came to me as an investigation. I'm a CPS investigator at the department.
Thank you. And you, did you prepare and sign this petition that's before the court today?
I did.
Originally, how did this matter, what was the original complaint for this matter?
So the original complaint was regarding Joshua Esterline and Daisy Esterline's home, and it came to me on 8/20 for physical injury.
And part of your investigation, let me rephrase that. In investigating that complaint, how did you become aware of Miss Gabriel?
So as part of the investigation, I do have to meet with both of the child's parents. And so I set up a time to meet with Melissa at her home to do a home assessment and to go through some policy questions with her. At that time, she did disclose to me that she had had a past history with pain pills and cocaine. And so I then drug screened her, which resulted in the investigation starting with her as well.
As it relates to Mr. Esterline, the allegations of physical abuse involving his wife, who was no longer involving his wife, what measures were taken to ensure Mr. Esterline's home remained safe for his child to go to?
When I met with Josh to go over the allegations, we did make a safety plan. He was also compliant with everything that I asked him to do. The safety plan included no physical discipline from him, not to allow Jaden to be around Daisy. Sorry, I need to start using just the initials.
Yes, thank you.
Sorry.
Yes, please.
Jay. I'll just refer to them as J boy and J girl because they're both J's.
Or older and younger, that helps.
That would work too. Okay, so the older child, let me back up. We safety planned that there would be no physical discipline. He would not allow Daisy to be around Jay, older. And then he also disclosed that he uses marijuana. So we safety planned he would store that properly and have a sober caretaker in place in the event that he does use that.
Was he able to articulate who the sober caregiver would be?
Yes, he listed at first Melissa, and he also listed his friend Matt, who he's now living with.
And were you able to confirm that the other, not Melissa, but the other individual was in fact a sober caregiver, or could be?
I have at this time no reason to believe that he is not. Or that he is not a sober, that he's anything but a sober caretaker, sorry.
And did you have an opportunity to go to Mr. Esterline's home where he's currently residing?
Where he is currently residing, I did not. Our fictive kin worker, Jill Heilman, did go, and she discovered that it was appropriate.
Okay. And you said there's no reason to believe that Mr. Esterline would violate any of the safety plans that he's voluntarily entered into. Is that correct?
Yes.
Okay. Relating back to Ms. Gabriel, you indicated that part of your investigation includes speaking with both parents. And Ms. Gabriel was forthcoming about prior substance abuse issues that she endured, correct?
Yes.
Okay. And you said that you did a drug screen at that point in time?
Yes, I did ask her.
I'm going to object on the grounds of, I thought what you're doing is establishing the probable cause for the father's admissions. What does that got to do with my client?
So I suggested that we consolidate the findings or the necessary fact exploration for both purposes. So I'm sorry if I wasn't clear on that. Is that a
You're
problem?
fine. I withdraw the objection.
Very well. Okay.
Okay. So you had done a drug screen for Miss Gabriel?
Yes.
Okay. What was the outcome of the first drug screen?
First drug screen, if I'm remembering correctly, was THC, cocaine, and fentanyl.
And at that point in time, what did you do?
At that point in time, I spoke with her about it. Well, not that exact day, but I did speak with her to follow up on that. I drug screened her again at that time. Let me back up again. So the day that I drug screened her, we had already signed a safety plan about marijuana use. And that safety plan states no illegal substances, don't use anything not prescribed to you. And there's a whole bunch of things on how to keep it stored. Like all of that is in that safety plan. I did not get that drug screen back that same day, but we had already decided that she had signed that, was good with that. I then get that drug screen back and it is positive for those things. I go back to her home, we discuss it. She states that she had not been using anything. She had told me the day after the drug screen that she had taken a friend's hydrocodone that was not prescribed to her. She was honest about that and said that might come back. However, that drug screen did not reflect a hydrocodone. So then when I talked to her, when I followed up, she said, oh, that might have been something in that pill that wasn't what I thought it was. So at that time, we do another safety plan. That was 9/10. We do another safety plan and just put it right on there. No illicit substances to be used. Please use sober caretaker. She at that time had chosen William Garland, her boyfriend, who lives in the home, to be the sober caretaker. So that was the follow-up.
And on that second drug screen, what were the results of the second drug screen?
The second drug screen came back for THC, cocaine, fentanyl, and xylazine.
Do you know what xylazine is?
Yes, it is a horse tranquilizer or a vet tranquilizer.
Okay. Yeah. Did you discuss those results with Miss Gabriel?
I did discuss those results with her. I came back on 9/19 and discussed. I also should add in there that I attempted many times to meet with her and they were all rescheduled, or I was unable to get a hold of her by phone, so I would unannounced try to show up. And eventually I was able to meet with her on 9/19. 9/19, we discussed that. She said that she had not been using again, but at this time she did consent to doing a community mental health substance abuse assessment over the phone while I was present. She did it on my phone. And she also did a mental health assessment at that time as well and agreed to partake in those services.
Did she, at that the 9/19 date, did she admit to using?
No. She said that she had previously used Percocet 30s prior to me being involved around the time of her father passing away, but she did not admit to anything else current.
At any point in time, did you contact the provider that performs the drug screens and determine if these substances would remain in her system for more than a month. I mean, if the drug screen was on 8/20 or 8/22, and then again on 9/19, they're both positive. Could it just been left over?
I didn't contact them specifically, but I do have my own printout from their website that gives the timelines of when all drugs should be in your system for. And xylazine, I do not have a specific timeline for. It's a newer, they just started testing for it, but for fentanyl, I believe
I'm
it's 4
going to
days.
object to
Okay.
her repeating what she's read from a chart.
Ms.
Unless
Simmons?
she's got independent knowledge, how am I going to cross-examine a chart that she read?
Your Honor, at this point in time, the rules of evidence do not apply. I think that she's simply being truthful about whether it was a concern for active use or not. And this is how she was able to inform her opinion about that.
Well, technically she's right, Mr. Brooks, so I have to overrule your objection, but I do want to acknowledge the weight of that objection. Clearly she's using this to make her decisions moving forward, and so she's relying on it for the truth of the matter asserted. But I will acknowledge for you that it has significantly less weight because it is pretty unreliable information at this juncture. Your next question.
So I don't think you were able to finish your answer.
Sorry. To answer your question, I did not call forensic fluids to ask them how the length of time, but we do have a chart that I printed from forensic fluids website that states that it would be 4 days, approximately 4 days.
And that was for the fentanyl?
For fentanyl, yes. Xylazine does not have, I tried to find it on their, and it does not have a timeline, so I'm not sure on that one. Cocaine is also 4 days.
Okay, so then when you see her on 9/19, did you do another drug screen? Because I think,
Yes.
okay.
Can I look at my petition to tell you what that one was positive for?
If you need to refresh your
Am I
memory,
allowed
that
to?
is fine.
Okay, so 9/19 came back for THC, cocaine, fentanyl, and xylazine again.
And then you did a fourth did you do a fourth drug screen with her?
I did. The fourth drug screen was from 9:30. No, oh yes, 9:26.
And what did that come back
9/26.
positive for?
THC, cocaine, and xylazine.
Since this petition, have you done another drug screen?
There was a drug screen pending for 9:30 as well when I did the petition, and I did receive the results for that. That one was positive for THC, cocaine, oxycodone, and xylazine.
And have you discussed
there
all
was
these
also-
results with Ms. Gabriel?
I did discuss the 9:20 or the 9:30 ones with her today at a family team meeting.
And at any point in time, has she acknowledged current usage of any of these substances that keep coming back on her drug screens?
Sorry, can I refresh my memory one more time on the
If
date?
this is to request information received at the family team meeting, is that admissible? That's really a question. Is that admissible in this court?
Well, for purposes of the preliminary hearing, basically everything is admissible on the removal, distinctly differently treated from the adjudication. And that is Michigan Court Rule 3.965, subsection B12 at the bottom indicates the Michigan rules of evidence do not apply other than those with respect to privileges, and except to the extent that the privileges may be abrogated by 722.631. For purposes of the preliminary hearing. Does that help?
It does.
Very well. Make it. I don't remember what the question was.
Sorry, do you? I kind of remember a little bit of what the question was.
So I just had asked at any point in time, had she acknowledged current usage of any of the substances that continue to show up on the drug screens?
Okay, so 9/26, she did make a comment to me that she had used cocaine a couple of weeks ago. And I had stated, I was involved a couple of weeks ago, and at that time you had told me you weren't using anything. And she said, oh, before you were involved. So at that time, it was still no current admittance of use. And then when I left the home that same day, I got a string of text messages from her that state I currently only use when my children are not home. But that was the extent of the admittance that I got.
For DHS policy or CPS policy, is substance use in and of itself a reason to petition the court for jurisdiction?
No. I don't actually know if that's a policy or not, but from what I've learned, no.
Okay. So what is the concern for Ms. Gabriel?
The concern for me has been throughout this entire time, we have created 3 safety plans just with her alone that she would no longer use substances. And that she'd utilize a sober caretaker. Those have all been broken just on the fact that she's tested positive every single time after the fact. Also, throughout my investigation, I've had concerns about the sober caretakers that she's given to me. There was also the second time that I visited, I had to visit unannounced because I could not get a hold of her. And after seeing her drug results, I was very concerned. So I showed up unannounced. And when she opened the door, she fell out the door twice that day and then tested positive for very lethal substances. So those are where my
Fell out
concerns.
the door, stubbed my
No.
toe on a nail.
No.
Those are where
There's
my
a
concerns
difference.
lie.
I'm sorry, did you say the kids were inside?
2 children were inside, yes.
The sober caretakers that were part of the safety plan, why do you have concerns about those individuals?
In the beginning, I did not have a concern. However, throughout the investigation, I learned that her boyfriend, William, who was the main sober caretaker she had chosen, was also utilizing alcohol. On 9/16, during one of my attempts to meet with her, I unannounced showed up to the home and only William was present. Per our investigation, we have to speak to the other adults in the home as well. So I took this as an opportunity to do policy questions with him, talk to him, safety plan with him if needed, and to request that he would do a drug screen for me because I had developed some concern from what I was seeing in her drug screens that he might also be. He did do all of the other stuff. He did say like all the policy questions and he safety planned because I had learned that he drinks alcohol. He safety planned that when he was in charge of the children to be the sober caretaker, he would not use alcohol and he would remain sober. I then asked him to do a drug screen. He said yes at first, then quickly recanted his yes, which is fine. But then he told me, I don't want to do the drug screen because I don't want to further complicate the case, which sparked a thought in my brain of why would you think that your drug screen would complicate the case? So I asked him, would it come back positive for anything? And he said, no, but I'll do it at a later date or if we get to a point where I have to. And I said, that what you're saying to me is concerning in itself. And he said, well, I'll just do it at a later date. And I said, and I also told him we were at the point of needing him to drug screen and he still said no. So that was concerning to me regarding him as a sober caretaker. And then he did end up drug screening on 9/30 after we were at a point where I was talking about court intervention being the next step. He called me and said, I'm willing to do it now. That drug screen came back positive for things, making him not a sober caretaker as well. And then what was the question again? So I make sure I'm fully answering.
What was the other, was there another individual that was indicated to be a potential sober caregiver?
Yes, there was other times where I had come over unannounced and the door was open. When I went up the stairs, the door closed and I had talked to Melissa through text and she said her cousin was watching the child, Jay Younger. Melissa was not home. So the next time I came to Melissa's and I safety planned about William not being the sober caretaker, she had said her cousin had watched Jay Younger before and that she would like her to be the sober caretaker. It was later learned that that individual has had prior terminations of their own and is not an appropriate caretaker.
At this point in time, what would be the proposed? Well, let me just start with, based on the information you have from your investigation, do you believe that there's a substantial risk of harm to the children's life, physical health, or mental well-being if they remain in Ms. Gabriel's care and custody?
Yes.
Can you just briefly elaborate what that risk of harm is?
I think the risk of harm of the continuous use of very dangerous and lethal drugs with failure to provide proper caretakers is the risk of harm to the children, as well as a minimizing of the use, which shows that there might not be a benefit. Well, I have a concern that there will not be a benefit of programs that are put in place for her to address the substance use. Those are my two major concerns.
Has Ms. Gabriel voluntarily participated with any substance abuse programming that you're aware of?
Currently, she is participating with Catholic Charities weekly.
And have you had the opportunity to speak with Catholic Charities if there's continued engagement and benefit?
I have called them to check in to see if she is doing her meetings or therapy sessions, and they did tell me yes. They sent me a assessment, and my only concern with it is that they talked about the fact that she was minimizing her usage while she did her assessment. But she is doing them, so all the times that I've known that she was supposed to have an appointment, she has done it so far.
The petition does not indicate that the children have suffered any physical abuse in her home or don't have adequate food or anything like that, correct?
Correct.
Okay. Did you attempt to, during the family meeting today, were there any attempts to safety plan the children out of the home?
Yes.
And has Miss Gabriel ever been agreeable to that arrangement?
No, both times that I've asked her during this family team meeting and outside of this court involvement, she has not been agreeable.
What would the plan be for the children if they were to be removed?
Oh, sorry. Currently, the plan would be that the older Jay go with his father, who I also have a safety plan in place for, and as you've seen, want in-home jurisdiction on as well. And then for the younger Jay to go with fictive kin, who she is familiar with.
Okay. Is there anything else that you believe is necessary for this court to know in order to make an informed decision on the petition today?
Yes. Am I allowed to talk about things that I've discovered since writing my petition?
At this point, if you believe that it's relevant, then yes, please.
Okay. So I did request records from a doctor's office, and I was told that neither child has been seen at either since 2022, and that they were discharged from both offices that I called, stating that they had missed 5 to 7 appointments each. I have a concern about that. I also have a concern that when the petition was served to Melissa, there were weed roaches all over the porch that were accessible to the children, which we, in our very first safety plan, discussed that those would be locked up and not accessible to children. And I made myself a list, sorry.
Could you explain what you mean by a weed roach?
Yeah, sorry, it's the end of a rolled weed cigarette. I'm not sure what to refer to it as, but it's like the very burnt end of it, but still could have weed in it. And it was left like cigarette butts almost, but for a weed cigarette kind of style. Okay. And I've already talked about the minimizing, so that covers that. I did also receive one more drug screen from 10-4 as well. And at that time, Melissa also tested positive for THC, cocaine, oxycodone, and xylazine. I also tested William again. He was positive for THC, and when they did ask him to do the test, he cracked a beer. So that covers the rest of my concerns.
And have the children been there when you are speaking with the parents, or I'm sorry, with Miss
Yes.
Gabriel and her partner?
Yes.
The children have been there. Okay. Is there I believe that it's established there's a custody order between Mr. Esterline and Ms. Gabriel.
Yes,
And do they have joint legal custody to the best of your knowledge?
to the best of my knowledge, Melissa has full legal joint, and it's all times agreeable for parenting time for dad.
Thank you. With that, Your Honor, I have no further questions of Ms. Fawcett.
Cross-examination, Mr. Brooks?
Thank you. My client showed me some rather graphic pictures of the bruises on her son's body. You're familiar with them, I assume.
I am.
You are not alleging that she was the cause of that bruising, are you?
No,
So the one thing that you are concerned about is drug use, is that right?
it's not the one thing. I'm concerned about multiple things, but that is one of them. Yes.
All right. You're correct when you say the policy is you can't use drug use as grounds for removal in and of itself. That is correct.
Thank you.
Your safety plan is geared towards ensuring a reduction in substance use of illegal substances, right?
Part of it, yes.
So if it's been unsuccessful and my client continues to test positive, that is not an enhancement of your case here this afternoon, is it?
Say that again. What do you mean by that?
Just because she continues to test positive for drugs over the months is not making your case stronger that there's a potential harm to these children, does it?
It's definitely not making it weaker.
You didn't answer my question.
I would say that the testing positive adds to the concern for the children.
Despite the fact that your own policy of your own department says it's not?
It cannot only be that.
What is your other concern?
My other concern is the sober caretakers not being appropriate. And still going to the home and seeing the children being there with only Melissa and inappropriate caretakers.
How is that an increase in the risk of harm to the potential harm to these children?
Because in the event that one of these substances that are very dangerous creates a problem for any of these people who are not appropriate, nobody will be there to take care of the children or to ensure the children have care or that they get the help that they need or the care that they need. That is the concern.
How is this different from every other drug user? Doesn't it, your standard pretty much negate the whole stated policy of the department on this issue?
I don't believe so.
I have no further questions.
Ms. Dang?
Yes, just briefly, thank you. Isn't it true that my client, Mr. Esterline, has never caused any injuries or physical abuse to the minor children himself?
Correct.
Okay. And it was rather his wife, Daisy, that caused the harm, correct?
Correct.
Okay. And are you aware that Mr. Esterline's wife, Daisy, is no longer in the home?
Yes.
Okay. And she is actually living in Ohio now, correct?
Correct.
Okay. And Mr. Esterline has moved out of the house regardless that they were living in. So if she did come back, she wouldn't be anywhere near him or the child, correct?
That is a safety plan that we've discussed. I don't know if she knows where he's living, but as of right now, she should not be.
Okay.
Correct.
And then are you aware that Mr. Esterline is currently in the process of obtaining employment?
Yes.
Okay. And that was a concern that was listed in your petition?
Yes,
for him,
I did not
correct?
know about the information until when the petition was being written, correct?
Okay. Thank you. I have nothing further.
Questions, Ms. Underwood?
Ms. Wazik, can you also confirm again that it's not just the drug use, but also Ms. Gabriel's behavior when you have visited that adds to your concern with her drug use?
Yes.
Okay. Has there been more
Say
than
that
one?
again?
Has there been more than one occasion where Miss Gabriel seemed to be under the influence when you showed up unannounced?
No, just the one instance of the falling through the door. Where I have noticed, other than knowing that she was testing positive at that time.
Okay. And does Miss Gabriel, when you discuss drug use with Miss Gabriel, does she seem to think that it is an issue?
No. Well, up until today, basically, no. Today during, I don't know if I'm allowed to talk about this, but during our meeting today at 9 a.m., she did say that they were horrible results from her screens. So she did acknowledge that it was a problem at that time, but it wasn't until today.
Okay. I have no further questions. Thank you.
Okay, any redirect?
No, Your Honor.
Any recross, Mr. Brooks?
No,
Ms. Stang?
No, thank you.
Thank you for your testimony. You may return to your seat. Thank you. All right. Will there be any further presentation as it relates to the plea being entered by Mr. Joshua Esterline, Ms. Thomas?
I have nothing further to add on that point. I believe that his admissions are sufficient, and as it relates to the request for in-home jurisdiction, I believe that Ms. Wassik's testimony also supports that he has been cooperative with the department, understands the risk of harm to his child, and he has continued to follow his safety plan put in place.
Any further presentation on the, well, maybe I'll just ask it this way. Are you satisfied with the advice of rights and the factual basis of the plea, Ms. Stang?
Yes, thank you.
All right, Ms. Underwood, same question.
Yes, Your Honor.
Ms. Thomas?
Yes, Your Honor.
Mr. Brooks? Any
No.
position? Okay. All right, well, the court is satisfied that the plea by Mr. Esterline is knowingly, voluntarily, and understandably made with a full understanding of the consequences, and that there has been a violation of the statute as cited by the department in that the children that he was tasked to keep safe were physically injured as a result of his decision on who to allow around as a caretaker. So that created an unsafe environment for them to live in, and a home also that contained a high level of risk for them to be in under his care, despite some safety planning around that. I am glad to hear that he has removed her from the home and that he's prepared to take placement of the child in order to demonstrate that he is able to keep them safe moving forward. All right, so we'll set up a time for your disposition. In between now and then, you'll have a meeting with the department to put together a case services plan to help support you continuing to provide a safe environment for the children or child. As it relates to continued removal or the request for removal from the mother, Ms. Thomas, your next witness.
I have no further witnesses on that point, Your Honor.
Okay, Mr. Brooks?
well, I think you can anticipate my argument from my questions. Policy of the,
Well, before you get into the argument, do you wish to call any witnesses today?
I do not.
Ms. Stang?
No, thank you.
What is your client's position on the request to remove from the mother's care?
He is in favor of the removal for purposes of the child's safety, and obviously is ready to take placement of the older Jay.
Ms. Underwood? Any witnesses today?
No, Your Honor. Thank you.
All right, as to argument then, Ms. Thomas?
Thank you, Your Honor. Generally speaking, CPS does not always have to become involved or open a case or file a petition for substance use alone. It's only when it becomes a threatened harm to the children. Ms. Wassick did exactly what she was supposed to do as an investigator. She continued to monitor Ms. Gabriel's use. She performed 6 drug screens, and over the course of, I want to say 5 or 6 weeks, all coming back for very serious substances, fentanyl and the xylazine and cocaine And at one point, Miss Gabriel had indicated to her that, maybe she took a pill that she thought was a Norco, but it wasn't. This sort of behavior and this level of use definitely poses a risk of harm to the children. There's the risk for an overdose, especially when the quote unquote sober caregivers are also using substances or have prior terminations and have been deemed unfit to care for children. Furthermore, there's the risk in minimizing the use as well. It is great that Ms. Gabriel has started to engage in services with Catholic Charities, but at this time it is early, and she has continued to use based on the screens that we have, and she may disagree with that, but they are continuously consistent. And for drugs that are only supposed to last 4 days before they would not show up in a drug screen, it's clear that she's not being very truthful in her use and what that might do to the children. We also have concerns because the children are present in her care, and that has been observed by Ms. Wasik as well. So, Your Honor, there were efforts made to, I believe that there's probable cause to indicate the custody with the children with Ms. Gabriel would pose a substantial risk of harm to their life, physical health, or mental well-being. And also take into consideration what it might be like for these kiddos to observe their mother under the influence of such potent substances. We attempted to safety plan around this several times, including appropriate sober caregivers, not using while the children are home, locking or putting away any of the substances, and still, even the end parts of the marijuana cigarettes being around certainly have all failed. That has not been successful in this case. She is not agreeable to allowing the children to stay with, one with his father and then another with an appropriate adult. And so at this point in time, there's no other provision or service other than removal that's reasonably available to adequately safeguard the children. We also believe that the testimony today demonstrates that continuing the children's residence in that home is contrary to their welfare. We also ask the court to consider that consistent with the circumstances, reasonable efforts were made to prevent and eliminate the need for removal. I think Ms. Wasik had spent a significant amount of time trying to avoid having to come to court. I don't think that's something any of the workers want to do, frankly, and they want children to be able to remain in their homes. But at this point, there's the conditions of the home just pose too great a risk to the children, and that the older child with his father under a case service plan or the jurisdiction of the court, and the younger child with a fictive kin placement would adequately safeguard the children at this point in time. So for those reasons, Your Honor, we are asking the court to remove the children from Ms. Gabriel's care and custody pending trial, and hopefully before then we can get some voluntary services going. Thank you.
Mr. Brooks?
Your Honor, I think this is exactly the kind of case that the policies promulgated by the DHHS meant to cover, that the use of controlled substances in and of itself is not grounds for removal. There are 34 paragraphs in this complaint. Nowhere does it say these children are being injured. Nowhere does it say they're being underfed. Nowhere does it say that these children aren't clean. Nowhere does it say that these kids' behavior is not age appropriate for their age. There is no allegation, objective allegation in any of these 36 paragraphs that says these children have been harmed in any way, shape, or form. So the question I ask again is, what has she done wrong? You can't just use the fact that she tests positive for controlled substances without some showing of harm or potential harm to these children. And these children are, how old are your two kids again?
9 and 3.
What?
9 and 3.
9 and 3. And nothing has happened. Nothing bad has happened. There is no harm. She's taking care of her kids. I don't personally know whether she's using controlled substances or not, but this investigation by what appears to be a very competent caseworker with the DHHS does not reflect to this court or to me that these kids have been harmed by this woman's parenting. And I think if you want in-home jurisdiction, I get it. But to say these children should be removed from this woman's care defies logic. These kids are fine. And nobody in this room can say that I'm wrong. These kids are fine. You want to keep track of things and have in-home jurisdiction, and you want to go check up on things, okay, I'll accept that, but not removal. Thank you.
Ms. Stang, could you tell me what the visitation order typically would be that your client would have with his child?
Every other weekend.
Thank you. Okay, your comments?
As to the removal, my client's position as to that is just that he does believe the children are at a substantial risk of harm, not that they have been harmed, but they are at a substantial risk after hearing the substances that were tested positive for on the drug screening. And as you've already heard, he obviously understands what the issues related to him are, and he has already taken steps to obviously rectify those issues and ensure that the oldest child can be placed with him safely. So we would just ask, obviously, that if the child is removed, that the oldest child, Jay, is placed with my client for in-home jurisdiction.
Ms. Underwood?
Yes, Your Honor. These cases are admittedly difficult when you have a parent who is a drug user. And while I understand Mr. Brooks's position to an extent, the amount of substances that Ms. Gabriel is testing positive for on a regular basis are incredibly concerning. Xylazine is one of the newer street drugs that's called trank on a slang basis. It's incredibly concerning, as well as fentanyl. Again, these are deadly substances that shouldn't be used at all. And again, if somebody is addicted to these substances, which again, it appears that Miss Gabriel is, I have a very hard time believing that she limits her usage to when she doesn't have her kids, when it seems that she's got them the vast majority of the time. The lack of compliance with 3 or more safety plans, I believe, shows that there's also probable cause of a substantial risk of harm. Ms. Wazik's testimony about the children not being seen by their physicians is also concerning. The minimization of Ms. Gabriel's usage is, again, also a concern. There is a threat of harm to these children, as it appears that, again, Ms. Gabriel is repeatedly using multiple substances that are not only illegal, but potentially deadly. And it seems nearly impossible for someone who, again, continues to show positive drug screens for multiple substances to be able to adequately parent their children. The lack of sober caregiver is very concerning as well. I believe that there are grounds for removal. I believe that the department did everything in its power to avoid us having to be here for this very reason today. So I would support the department's recommendation for in-home jurisdiction for the older child and to have the younger child placed with fictive kin in order for Ms. Gabriel to be able to utilize services to get clean, sober, and my apologies, for Ms. Gabriel to get clean, sober, and be able to address the issues that have brought the department into her home. Thank you.
All right, we're going to take a brief recess for me to chat with the attorneys by sidebar on this case, and then I'll come back out and give you my ruling. In the meantime, I just wanted to let Ms. Wadzik know that I am going to need a copy of that custody and parenting time order. So if you could put a pin in that, please, and I'll also look at scheduling with the attorneys before I come back out as well to get them. I had indicated I would make my ruling when I was able to reconvene, but then I wanted to chat with the attorneys who have all rejoined us. And I understand there may be some updates that change whether or not I need to make that decision.
That's correct, Your Honor.
Why don't we start with Ms. Thomas on the position of the department?
Thank you, Your Honor. In our discussions, we had went over the link of substance use and the risk of harm to the children and whether there were alternatives to removal. And at that time, the department agreed that in-home jurisdiction at this point in time may be appropriate in order to have the least restrictive environment for the child, given that there are no other allegations in the petition about, like domestic violence or overdosing or neglect to the children. But obviously the types of substances that are being used are very concerning, and we believe that in-home jurisdiction would be appropriate at this time.
Mr. Brooks?
And with that decision by the THHS, my client is willing to acknowledge and admit that the court has the right to take jurisdiction in this case.
Any position, Ms. Stang?
No position as to that.
Right?
Ms. Underwood?
Yes, Your Honor. I agree that at this time, in-home jurisdiction is appropriate. I do just want to note for the record that as GAL, I do have great concern for the welfare and the well-being of the children. However, I believe that this agreement is appropriate in order to help facilitate some services for mom and hopefully the safety of the kids.
All right, and with that being said, he's not here. Mr. Brooks, your client has been sworn. Ms. Gabriel, you remain under oath. Do you understand that?
Yes.
Okay. So is it true that you wish to enter a plea, understanding that the request has been changed to in-home jurisdiction and the request for removal is off the table?
Yes.
All right. So I went through a lot of the rights already with Mr. Esterline, and I'm going to go through those with you as well. Okay. All right. If I accept your plea, you are giving up the right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving those rights if you enter a plea?
Yes, Your Honor.
With regard to the consequences of your plea, or in other words, what will happen, there will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. Gabriel? I'm sorry?
Yes.
Okay. Do you have any questions about any of the information I've given you so far?
I do.
Is anyone making you admit to the petition? Has anyone threatened you in order to get you to admit to the allegations in the petition? Outside the terms of the plea agreement, which really effectively just took removal off the table for today, has anyone promised you anything in order to get you to take a plea? Are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing right now? Would you say your decision to enter a plea is one you've made of your own free will? Very well. All right, as to the factual basis of the plea, Ms. Gabriel, obviously there's been a lot of conversation this afternoon about positive drug tests, about potentially you admitting to using some of these substances, as well as many other things in the petition. I guess maybe Mr. Brooks would be the better person to ask this. Are you admitting to singular aspects of the petition or just the petition in its entirety, Mr. Brooks?
Petition in its entirety, Your Honor.
So Ms.
We're not
Gabriel,
in the mood to dance.
all right, so essentially, basically everything that's in that petition and everything that I've heard today is what I would consider. Do you understand that, Ms. Gabriel? Is that what you'd like me to consider?
Yes.
All right, very well. Okay. All right, any objections to the court proceeding on that basis, Ms. Thomas?
No, Your Honor, thank you.
So I guess the better question would have been, are you satisfied with the advice of rights and the factual basis of the plea?
I am. Your
I
Honor,
am,
thank you.
Your Honor.
Yes.
That leaves us with Ms. Underwood.
Yes, Your Honor.
All right, and do you also find that it's in the children's best interest for me to accept Ms. Gabriel's plea?
Yes, I do, Your Honor.
All right, thank you. The court finds the plea to be knowingly, understandably, and voluntarily made. I further find that the record does support that one or more of the statutory grounds alleged in the petition are true. There was a number of safety plans around using substances, providing chauffeur caregivers that were frankly violated here. There is evidence of use of really dangerous substances that obviously raise some significant concerns about whether or not, Ms. Gabriel, whether you are trying to effectively parent under those substances, and frankly, whether or not that could create a situation where you need emergency services because of some of the strengths of these substances that are being used. So there's a lot of concern here. The testimony about finding some of the leftover marijuana cigarettes where the kids could find them is also concerning, frankly. So for all those reasons, I do think that services are necessary and that there is a risk of harm at the home based on what I've heard here today, to the extent that the petition should be authorized and I can take jurisdiction under the statute the same statute sections that I took jurisdiction as it relates to Mr. Esterling, but obviously for the reasons of the use of those substances. I will also say that there's been a lot of argument today about whether or not use of substances is simply enough and whether or not we need to have more evidence than what we saw as far as perhaps you stumbling out the door, right? So there was very little evidence on that point. But part of what we talked about in the back is typically when that argument is used, it's about substances like alcohol or marijuana. The substances that we're seeing here, Ms. Gabriel, are significantly more dangerous. And there was a potential here that there is some case law out there that would have supported that simply using those substances would have been enough for removal. And I'm bringing that to your attention because I want you to understand that just because we're not removing your children today, I need you to take this very seriously and to really come to the table and talk with your service providers at Catholic Charities about why you think you need to use these things and about how that could be affecting your children. Even if you're meeting their basic needs, being around a child under the influence of a substance like this is surely impactful, right? They're going to know that they're going to be noticing this. This is not something we want to normalize for them. So I'm going to ask you to meet with the department to put together a case services plan that really targets those areas and improves things both for you and for your children. Okay? All right. I'm going to order the DNA testing for the other child as well, for Mr. Christopher Cassar. And I'd like to ask the department too, as you look at the case services plan, to look at visitation here. So obviously, Mr. Esterling only has every other weekend right now. I would really like the parties to come to the table to look at involving him more in their lives and maybe balancing that out with Ms. Gabriel's available time frame to work on some of these challenges that she needs to face. To look at Mr. Cassar's DNA testing to get that underway and also visitation if that's something he wants to explore in the meantime. Any questions on that?
No, thank you.
Okay, we'll be back then to look at the case again and on those case services plans for both of these parents that are here today on November 4th at 1:30 p.m. as well as to have a look at that putative father issue for Mr. Kassar at the same time. I think I've given you some guidance moving forward. Was there anything else?
Not at this time, Your Honor.
And thank you.
All right. Thank you, everyone, today for your time and efforts and your willingness to have a look at these issues to make things better for yourselves and your children. We'll see you in November for the initial disposition regarding both children. May I have the names of our participants, please, beginning with our guardian ad litem? Uh-oh, Nicole Underwood.
She texted me earlier and said she was on.
Okay. Well, let's go around and introduce who all is still here.
Anastasia Thomas, counsel for the department.
Megan McVeigh from the department.
Michael Brooks, I represent the mother, Melissa Gabriel. Would you identify yourself?
I'm Melissa Gabriel. I'm the mom of the kids.
Alexis Stang, appearing on behalf of Joshua Esterline, respondent father.
I'm the father, Joshua Esterline.
Okay, who's coming in under CJ's phone?
Christopher Kassar.
And what brings you into the courtroom this afternoon?
I was told to be here for the hearing.
Judge Sala, I believe is the father for one of the other children.
Oh, Christopher Kassar? Is that what you
Yeah.
said you were? Okay, thank you. Well,
Thank you.
I'll go back to my office. Okay, good afternoon, Ms. Underwood. May I have your appearance on the Gabriel Esterline case, please?
Yes, good afternoon, Your Honor. Nicole Underwood, legal guardian ad litem for the minor children.
Okay, we are ready for your report whenever you are ready to give it.
Yes, I was able to meet with both children late last week. The older child I met with at his school. He is just a bright little boy, very personable. He appeared to be appropriately dressed. He was excited to talk to me about school and what he liked in school and the subjects that he enjoyed. Seemed to be doing very well. I went to Miss Gabriel's home and met with the younger child, also another very happy child. Giggled the whole time, smiled, showed me her toys, showed me the things that she had in her home. She also seemed appropriately dressed. I believe that at this point in time, their needs seem to be being met, although there are concerns as the GAL just with the drug use of mom. But other than that, like I said, at this point, the children do seem to be doing well with where they are, and they seem, like I said, they seemed to be healthy and happy kiddos.
Your first witness, Ms. Thomas.
Yeah, no problem, Ms. McVeigh. Afternoon, Ms. McVeigh. You've prepared a court report for today's hearing, is that correct?
Yes.
And part of your court report will include several attachments, the proposed case service plans for Ms. Gabriel, Mr. Esterline, and then there's court orders for the custody matter for the older child, the DNA scheduling information for the youngest child, and then some forensic fluid drug screens and a family team meeting note. Is there any other information that you've circulated since you've filed this report?
The only additional information I have is another positive drug screen for Miss Gabriel.
When was the last drug screen sampled? What date was that taken?
I left, it's right there on my phone. Can I come get my phone?
You're ready to take
I can get it for her.
black or pink?
Black, please.
Thank you.
There's actually two that I have one pending from, let me get the date here. No, it's gonna spin. There's one pending that was collected on 10/30, and there is a positive drug screen that was collected on 10/24/24.
Well, what was it positive for?
it was positive for THC, cocaine, the benzo, that's the metabolite of cocaine, and fentanyl.
And that's, I'm sorry, that was for Miss Melissa Gabriel?
Yes.
As it stands right now, do you still believe that there would be a risk of harm to the children if they were to, if the court were not to exercise jurisdiction over the family?
Yes.
What would be the risk of harm without the court ordering the parents into a case service plan?
Just the continued concerns from the petition involving substance abuse. Both parents, however, are very cooperative and are willing to participate in services. Both of them have started services and are willing to complete services. We just haven't had a lot of time to get those services going and get things started and alleviate the concerns from the petition.
Thank you for that information. And just to be clear, for the parents' sake as well, the goal for the children is to remain at home with them. Is that correct?
Yes.
With the ongoing concerns for substance use and the substances that are being used, I think is the main concern here as it relates to Ms. Gabriel. Have you discussed further safety plans? I know that was attempted before, but have there been any other safeguards put in place?
Not additional to what was done before.
In your opinion, are there any safeguards that could be put in place?
Additional
Yes.
ones? Not at this point.
What are some are there any voluntary services rephrase this. You mentioned the parents are already very cooperative and engaged in services. What services have they already engaged in?
So Miss Gabriel is doing forensic fluids, drug screens. She's doing substance abuse services. She started at Catholic Charities, but she transferred to McCullough Vargas to be more involved in the women's programs, and she really likes it a lot better there. So that started. She also had a consult with her doctor about possibly getting on some medication assisted treatment. And she's also participating in the My Family Together program, which she's been doing really well, making all of her appointments with that. She also made doctor's appointments and followed through on doctor's appointments for the kids. And we're still working on the dentist, but we're getting there.
Okay. I know that we recently had a family team meeting regarding parenting time. For the record, can you just quickly highlight the proposed parenting schedule that would, in your opinion, adequately safeguard the oldest child?
I just gotta refer to my notes because I get confused about this. He started, I know the oldest child went to his father's house on Friday. And so that was really good because it'd been a significant period of time before that he had not seen his dad, and they were both looking forward to seeing each other. They both told me that. Parenting time for dad will be every Monday at 6 p.m. through Wednesday at 6 p.m. Mom shall have every Wednesday at 6 p.m. to Friday at 6 p.m. The parties shall alternate the weekends, which consist of Fridays at 6 p.m. to Monday at 6 p.m. Dad's weekends will begin on 11/1, which they did. This is the parenting time that the parties shall follow unless they otherwise agree, and the parties shall work together to equally divide holidays so the child has holidays with both parents. And they do get along with each other. They're able to communicate. A lot of times we don't get that with parents, but they are able to, hey, today's a basketball game. It's a couple hours or whatever. Like they can speak to each other, which is really nice, honestly. So
Wonderful.
it's better for the oldest child.
Thank you so much for that information. The case service plans that are attached, do you believe that those adequately address the concerns that cause the court to take jurisdiction of the family?
Yes.
And were you able to create those with the input of the parents?
Yes.
Is there anything else that you would like the court to know?
The only modification that needs to be made that I just thought of is on Mr. Esterline's case service plan. It talked about he's willing to do the My Family Together program. However, there are no openings, and I don't know when there's going to be an opening. And I'm afraid it's going to be a very long time, and I don't think that's fair. So I was able to get on letter I that he'll work with the family assistance program.
Okay.
He'd agreed to that.
Thank you for that.
Yes.
Is there anything else that you'd like to state for the record?
No.
With that, Your Honor, I would move to admit the court report with the attachments.
No objection.
I have no objection either.
No objection.
Received. Thank you. Cross-examination, Mr. Brooks?
No.
Ms. Stang?
Yes, just briefly. You testified as to the voluntary services that Ms. Gabriel has already participated in, but could you let us know if and what voluntary services Mr. Esterline has already participated in?
Yeah, he is willing to participate in whatever we ask him to do. However, the one thing that we would like to see him work on is parenting skills. And he was willing to work with the My Family Together program, which is a more intensive program, but I'm afraid there's not going to be an opening for several months. So we just spoke, I just got an opening on Thursday. It's called the Family Assistance Program. So that'll be less intense, but I think it can address the concern.
Okay. And then I noticed that in the case service plan, it also says that he will submit to forensic fluid drug screens when requested. Has he been requested to submit to any of those yet?
I have not asked him to resend. No.
Okay. I have nothing further. Thank you.
Ms. Underwood?
I have no additional questions. Thank you.
Redirect?
Just a point of clarification. There's one drug screen in here for Mr. Esterline.
Yes.
Report, but that was done
prior to the case transferring to me.
Okay. And that was positive for THC, and there's no concern about, there's a safety plan in place for use and storage and all of that.
Yes, and there were other, was there just one that I attached? I can't remember. Yes, so just one. There's no concerns with substance abuse, and he did safety plan around the THC. Yes.
Thank you. No further questions, Your Honor.
Any recross on those questions?
No, Your Honor.
No, Judge.
No, thank you.
Thank you for your testimony. May you return to your seat. Anyone else you'd like us to hear from, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
No.
Ms. Stang?
No, thank you.
Ms. Underwood?
No, Your Honor. Thank you.
All right, comments in closing, beginning with Ms. Thomas.
Thank you, Your Honor. At this time, we're just asking the court to enter the parents into the proposed case service plans. I believe that as Ms. McVeigh testified, they are adequate to address the concerns that caused the court to take jurisdiction. I think with the parenting time set up, it will be really beneficial, not only for the kiddo, but for the parents to be able to work through some of those elements. And it's really nice to have parents who are motivated and will work together. I know that they also want to address child support and all of those things, and it seems like they're on the same page. So it's just kind of refreshing to have that here. And I know that there are some concerns, obviously, with moms still testing positive, and they think that's something we need to monitor, just to ensure that the kiddos are safe. Ms. McVeigh has already done some due diligence with the DNA testing scheduled for Mr. Kassar and the youngest child. So we'll continue to look forward to the results of that. I don't know if we're noticed for putative father hearing, but if we are, I would just ask for an adjournment until the next review, at which point in time I'm hopeful we would have results back, with the understanding that if Mr. Kassar is the biological father, there would obviously be some steps that he could work through with Ms. McVeigh to establish a relationship with a child, if that's the intent there. But otherwise, just a standard 90-day review. And that's it. Thank you.
Any comments, Mr. Brooks?
If it ain't broke, don't fix it. Everything's going fine.
Well, with the exception of your client's drug test results, but I trust that she's ready to start tackling that.
I'm working hard on it here.
All right, any comments today, Ms. Stang?
Nope, just we're just requesting that you enter the case service plan and that a standard review be set.
All right, Ms. Underwood.
Thank you, Your Honor. Yes, I think that it's appropriate at this time to continue the at-home jurisdiction. However, I do agree with Ms. Thomas that close monitoring of Ms. Gabriel's drug use needs to continue, and I think Ms. McVeigh's done a great job of doing that so far. Ms. Gabriel and Mr. Esterline, they have a great 9-year-old boy. He's a wonderful kid, and I would hate to see him have to be removed from either of their homes. So I trust that they're going to continue working hard toward working on the case service plan and continuing to work together in order to provide a better life for their child, as well as Ms. Gabriel has a vivacious little 3-year-old that, again, needs her mom and needs a healthy mom. So I'm hoping that she's going to continue with addressing her addiction and working towards sobriety, and really look to see again if outpatient's not working, what other options may be available so that she can get the help that she needs. But I'm also, requesting that the at-home jurisdiction continue and that the standard review apply. Thank you.
Okay. Well, the court finds all interested parties were given notice for purposes of today's hearing. We do have a copy of the judgment of paternity, which addresses custody to an extent. It doesn't look like the parties really concluded that. It was disputed at the time of the entry in November of 2021. And it looks like the child support was calculated at every other weekend for Mr. Joshua Esterline. So I do want to say I appreciate that being entered. And I appreciate the parties working together to put together a visitation plan. Is that in the family team meeting notes? Is that where that's at?
Yes.
Okay, can we incorporate that into the case services plan moving forward?
Yes.
And would you, Ms. McVeigh, also be willing to maybe look into the front of the court option for cementing that into an actual agreement in the child support case? There's a form down at the front of the court that the parties could utilize in order to ask for that to be modified.
Okay.
Potentially.
Sure, Sala.
Let me ask you to, yeah.
I actually am planning to help my client with that.
Great. Excellent. Well, then poor Ms. McVeigh won't have to try to figure it out. Good. Glad to hear it. Yes. Did you review all of these documents in here, Ms. Stang?
Yes, I did.
Okay. So was your conclusion the same as mine, which is that there's sort of a de facto every other weekend?
Yes.
But nothing. Okay, very good. So I appreciate you paying attention to that. Good. So we'll get that in place, which hopefully will allow us to look at permanency in the long run as the parents work on their challenges. The case services plans do appear to be correct and target the areas in which both parents need to make some progress, and we'll watch that progress as they work on those services moving forward. And we'll do a review in 90 days. The children will remain placed with their mother and exercising visitation with father in the next 90 days as well. And then we'll look also for an update on the DNA. It does look like there was a case opened against Mr. Christopher Cassar by Ms. Gabriel, but that was never, that did not reach a conclusion potentially because of lack of services. It looks like maybe, or service, process service. So we'll await DNA and go from there on his case. And we'll do a review in 90 days. You give me a date. How about January 13th at 1:30 p.m.? That's a Monday. Any issues with that time-wise? Okay. Okay, so we'll be back for a review on Monday, January 13th at 1:30 p.m.
I'm sorry, Judge. I have 2 pre-trials at 2 o'clock and 2:10.
I appreciate you letting me know. Let's go out to, how about Tuesday, January 21st? 1:30?
I can do that.
All right, Tuesday, January 21st at 1:30. Any other questions? No. All right, I'll have you 142NA. Thank you. We're on record for our first regular review for both parents' progress on their case services. We have the names of our participants, please.
Afternoon, Your Honor. Nicole Underwood, lawyer, guardian ad litem for the minor children.
Ms. Taja Thomas, counsel for the department. Ms. McVeigh.
Megan McVeigh from the department.
Michael Brooks, I represent the mother, Melissa Gabriel.
Melissa Gabriel, the mother of the children.
Alexis Stang on behalf of the respondent father.
Your name for the record?
Joshua Esterline, the father.
Thank you. Very good. Okay, Ms. Underwood, whenever you're ready with your report.
Thank you, Your Honor. I was able to meet with both minor children in person during this reporting period. I met with the son at his school. He seems to be doing very well. He is excelling in his classes. He's very bright. He talked to me about his holiday and his relationship with his little sister. He indicated that he is having parenting time with both parents, and he seems to be doing well, although he does say it can be a little chaotic at Dad's house due to the amount of people living where Dad is at, but his needs are met at both places, and again, he's doing very well overall. I met with Miss Gabriel's daughter. We'll call her Jay. She's doing very well. We played with her toys. We played with her Peppa characters. She was eating lunch when I got there, and just overall very happy. Seems to be very healthy and doing very well. Her needs are being met with her mom, and she's adjusting to her school, but she's doing well overall there. And at this time, again, both children's needs are being met, and they continue, their best interests continue to be served by being placed in home with their parents. Thank you.
Okay, testimony today, Ms. Thomas.
Thank you, Your Honor. I'll ask Ms. McVeigh to be sworn in.
Come on, are we to stand?
McVeigh.
Thank you. Ms. Thomas.
Thank you.
Thank you.
Ms. McVeigh, you prepared a court report for today's hearing. Thank you for providing that to us. There are several attachments, so I just want to review them to make sure we all have them. Your cover sheet indicates there's the court report, a case service plan for mom and dad, forensic fluid screens for mom, and I believe that there are 4 attached. And then there's the FAP termination report for dad, a progress email for mom from Akala Vargas, and then a progress letter for the oldest child from the CAC office, and then my family reports for mom for it looks like it would be October, November, and December. Are there any other documents that you've circulated since filing this court packet?
No, there's not.
Okay. And to the best of your knowledge, are there any updates or modifications that need to be made to your court report or any of those attachments that I listed?
I don't believe so.
Okay. And generally speaking, both of these, this is an in-home jurisdiction matter. So it's a little wonky, I think, sometimes with questioning, but generally speaking, during this review period, how have the parents done with their case service plan?
They're both doing really well. The father has successfully completed the FAP program. He recently expressed to me that he would like to start some counseling, but we had to get some insurance started for him first. So this morning he was able to turn in all the proofs that he needs so he can get the insurance going, and he's doing what he needs to do. The mother, Miss Gabriel, has been also doing extremely well. She's in a lot of services, and she's been able to make all of her services. The most recent drug screen I have for her was only positive for a little bit of THC, which I was really proud of her for that. She's been doing really, really well. She's been engaged in lots of services through McCullough Vargas. She's also been working with the My Family Together program and making sure that the oldest child makes his appointments with his counselor. And she also had made medical and dental appointments for the children.
Wonderful. And at this point in time, there's clear that we've determined there's no risk of harm to the children remaining in their parents' care and custody. Is that correct?
Yes.
Okay. And at this time, would there be a risk of harm to the children, in your opinion, if the court were to terminate jurisdiction at this point in time?
I don't think there's a risk to the children. The only reason I didn't ask for the court to dismiss the jurisdiction at this reporting period is I would like to see some more negative drug screens on the behalf of Miss Gabriel, which we've talked with everybody about that, and she's been doing really well. So I would expect her to continue that as well, because we only have the negative screens from December.
So it sounds like ensuring some continued progress with her substance use.
Yes.
Okay. Are there any other services that the family would benefit from at this time?
The only thing I can think of is counseling for Mr. Esterline, which we're working on it. He's been working on getting all that all set up, so.
Okay. And it looks like there's some work being done for the youngest child in establishing paternity.
Yes, a referral was made. The punitive father was a no call, no show. So another referral was made. And for whatever reason, they couldn't get Miss Gabriel and the youngest child in until the 28th this month. I don't know why it took so long for that, but that appointment was not missed. That was the original appointment. So.
Okay. For Mr. Kosar, it says that a referral was made on 114. Was that the date of the next scheduled appointment, or that's just when you sent him the new referral?
That's when I sent the new referral.
Okay. Okay. And so has that been scheduled? I'm sorry if I missed that.
I don't have a date yet.
Okay. That's okay. Thank you for clarifying. And then as it relates to how parenting time is going for the oldest child being between both parents, how is that working out?
It's been going well. It's really nice to work with a mom and a dad that can get along and can coordinate with each other and work as a team to make sure that the child's needs are being met. We don't get that very often, so they are able to work together and make sure all of his needs are being met. And if something comes up, they can call each other to, make sure that one of them is able to meet his needs at the time.
Wonderful. And it also looks like Miss Gabriel, her live together partner, is also voluntarily engaging in these services with her as needed or
Yes.
as appropriate.
Yes.
Wonderful. And is there anything else that you would like the court to know?
I don't think so, just that they're doing really well.
Okay, thank you. With that, Your Honor, no further questions of Ms. McVeigh, and would move to admit the court report and the attachments.
No objection.
No objection.
Counselor?
No objection.
Thank you. Did I receive questions for this witness, Ms. Stang?
Yes, just briefly. With regards to Mr. Esterline, I know you stated that he is in the process of starting therapy. Is there anything else that the department would like to see him do that he isn't already in the process of doing?
No, he's done everything we've talked about. He's actually the one that brought up that he would like to do some counseling, so.
Okay, perfect. And then I know I also saw in the submitted documents that it was reported that Mr. Esterline is currently taking the steps that he needs to get a divorce. Do you have any more information on where that is at or anything to add to that?
No, I don't.
Okay, I have nothing further. Thank you.
Okay, what's the status on the custody and visitation arrangement for the parents of?
I'm gonna mess this up. They have a date coming up very soon for that.
Okay, because I know that under the direction of this court, their parenting time has been modified.
Yes,
But that would need to be reflected in their custody case in order to be
yes.
a more permanent arrangement. Okay,
I believe it's next week.
okay, thank you.
Yes.
Questions, Mr. Brooks?
What is the risk of harm to these two children if the judge releases jurisdiction today?
There's not right now. The only reason why I'm asking for an extended, like I said earlier, is more consistent negative drug screens.
Thank you. That's all.
Questions, Ms. Underwood?
Ms. McVeigh, I noticed in Mr. Esterline's case services plan, it indicates that he would take drug screens as required by the department. Have you screened him at all during this reporting period?
I actually haven't. His last drug screen that he took for us was only positive for THC. I haven't had any concerns or any reports that he's been using any sort of substances, so I have not.
Okay. And where is the location that Mr. Esterline is living?
On Beecher Road, he lives with a friend.
Is that a long-term, is it a rental situation or is that just a temporary living arrangement?
It's temporary, living arrangement for now.
Okay. Has there been any discussion about what long-term housing is going to look like for Mr. Esterline?
Yes, we actually discussed it right before we walked in the doors today, and he does have plans of getting his own housing. He hasn't been getting a lot of hours at his work, and so he's been working on possibly getting a new job so he can afford that.
Okay. Is the plan for Mr. Esterline to stay in Lenawee County or to return to Ohio?
Lenawee County, I believe.
Okay. Are there any concerns with the current living situation that Mr. Esterline is in?
No, I know it's kind of a lot louder at his house and there's more people and, but there's no like concerns, safety concerns.
Okay. It was brought up that the son is when he stays with Mr. Esterline, he's sharing a bedroom with a non-relative child. Can you just explain who he's sharing a bedroom with?
It's the homeowner's son.
You know how old he is?
I believe he's 13.
And the department has no concerns with that living or with that arrangement?
No, I don't have any concern with the young man that he's sharing a room with.
Okay, thank you. As far as Miss Gabriel goes, do you think she would benefit from continued support from the department for one more reporting period, not only just for the drug screens, but for additional support that she receives from the department?
Yes.
And is that something that Miss Gabriel has indicated she would benefit from?
Yes, we've discussed that.
Okay, thank you. I don't have any further questions.
Any redirect, Ms. Thomas?
No, Your Honor.
Any other questions, Mr. Brooks?
No.
Ms. Stang?
No, thank you.
Ms. Underwood?
No, thank you, Your Honor.
Okay, thank you for your testimony. You may return your seat. Anyone else you'd like us to hear from, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
No.
Ms. Stang?
I would just call my client for a few questions.
Okay, all right. So Mr. Joshua Esterline, please come on up to our witness stand.
Mr. Esterline, have you heard the testimony that was just given this morning, this afternoon, I guess now?
Yes.
Okay. Did you hear the testimony about your current living arrangement?
Yes.
Would you like to expand upon that?
Which part of it?
So, do you currently live with a friend?
Yes, I do.
Okay. Do you plan to stay in that living arrangement long term?
No. It's not long term, as short as possible.
Okay. And then with regards to your job, what are you currently in the process of with regards to that?
I'm getting like minimum hours. It's fast food, so sales went down, my hours went down. So I'm trying to find a full-time job to be able to afford full-time bills.
Okay. Have you actually applied anywhere yet, or are you still looking?
Yeah, I've been on Indeed like nonstop and searching today even. So.
Okay. And then do you plan to stay in Lenawee County?
Yes, I'm from here, staying here.
Okay. And then I know it was mentioned, like I said, in the packet that was submitted as part of the court report that there was some indication that you were in the process of seeking a divorce. Is that accurate?
She said she was going to file for one, and after I was financially stable, I was for sure going to be, yes.
Okay. Is there anything else that you would like the court to know that you haven't already stated or that you haven't heard anybody else state today?
No, ma'am.
Okay. I have nothing further. Thank you.
Any questions for Mr. Esterline from any of our other attorneys?
No.
No, Your Honor.
Just briefly, Mr. Esterline, does Daisy Esterline have any contact with your son?
Never.
Thank you. No further questions.
Okay, thank you for your testimony. You may return to your seat.
Thank you.
All right. Anyone else you'd like us to hear from? Ms. Stang?
No, thank you.
Our other attorney here, Ms. Underwood. Any witnesses today?
No, Your Honor. Thank you.
Comments in closing then, beginning with Ms. Thomas.
Thank you, Your Honor. At this time, we're just asking the court to maintain jurisdiction so the parents can continue to take advantage of and benefit from the services that are being offered with that additional support. It is wonderful to be able to come back, after a review period and see the progress that's being made and to know that the children are doing well. I know there was some grave concern about Ms. Gabriel's substance use, and it's wonderful to see that she's having some of those clean screens. And I think that, as you know, sobriety can be really hard. And I think giving it another review period will really show her commitment to sobriety and being able to be that sober parent for her children. Otherwise, I think that they're doing exactly what they need to do and they're following their case service plan. And I would just like to commend them for that. Thank you.
Okay. Comments, Ms. Stang?
Just that I believe that my client also would benefit from one more review period to allow him to have the help of the department in finding a new job, the application process, and as well as setting up therapy. It sounds like he has already received the help of Ms. McVeigh for the therapy process, and it sounds like he is benefiting from those services. Other than that, it sounds like he's doing what he should be doing and is at where he needs to be. So we would request case closure after the next reporting period.
Mr. Brooks?
Well, I asked the $64,000 question. Is there any unreasonable risk of harm if the court were to release jurisdiction today? The answer was no. I think that answers all questions, and the court should release jurisdiction.
Ms. Underwood?
Your Honor, I think it's appropriate at this time that both parents in this matter do have one more review period in order for Miss Gabriel, for her to show some more extended sobriety. And honestly, my conversations with her support the fact that the department is here to help and here to help parents get back on their feet and have the tools necessary and the support necessary that they need to succeed. And this is the perfect example of the department working with a parent who is benefiting and wholly engaging in those services. So I do think that it would be in the best interest of the children for Ms. Gabriel to continue for at least one more review period, even if it's, a 60-day review, something to show sustained sobriety and those additional services that she's receiving. I also would agree that Mr. Esterline would benefit from continued therapy and services. Again, the reason why why the department was even involved in the first place was due to some physical harm to the oldest child, and the fact that he is still married to that person and does not have stability to be able to care for that child is a concern, but I understand that he's working on it. And I think with additional time, he will be able to get back on his feet and show some progress with respect to the pending divorce, as well as some full-time employment and sustainable housing. So I would ask for the court to consider either a 60 or 90-day review in order to allow a little bit more time for the parents to benefit from the services offered by the department. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of today's review hearing. I do find reasonable efforts towards the goal of reunification and support of the family are being made, spearheaded by Ms. McVeigh. The parents are engaged. There were very clear issues in this case at the outset, and the parents have taken affirmative steps towards remedying those. And I really want to say I do also appreciate it. It's good to see that Ms. Gabriel has made some progress on perhaps a surprising issue that was discovered in the family, but I'm sure has been a challenging one for her. So congratulations on that. I know that was not an easy task for you, and you've made quite a bit of progress just in a short period of time. Mr. Esterline, I would encourage you to reach out to Ms. Stang. She does a lot more than just our cases, and she may be able to give you a few tips on getting your filing for divorce underway. For certain low-income individuals, there's a filing fee waiver available to you. So if you wanted to take affirmative steps on that, she may be able to, in conjunction with giving you some advice on this case, talk with you about that, because obviously that affects the permanency and the long-term household for the two children concerned by this case as well.
Okay, most definitely. That helps me a lot, actually.
Good. Well, there she is. She's available to you, I'm sure, virtually off record as well. All right. I will keep the case open for another 60 days. I'm curious to see what happens with your situation, Mr. Esterline, and hopefully that stabilizes. I'd like to see what happens at your next front of the court case as well, and what you two decide to do with your visitation agreement. Support obviously is always affected by that. But I would offer you a somewhat short review period. We usually go 90 days, but I can take it back a little bit to March 31st, Monday, March 31st. It'll be somewhere in the middle of 60 and 90. Do you have a work schedule, Ms. Gabriel, that we need to be?
Not currently.
Okay. All right. So right now I have 10:30 in the morning or 1:30 in the afternoon. Anybody have a preference?
Morning time, just because of the convenience of Jake, my son.
Sure. Okay. So let's go 10:30 Monday, March 31st then for our next review period. In the meantime, the children will remain placed with their parents who are diligently undertaking services with the support of Ms. McVeigh, and the order will contain the rest of the findings necessary to support that ruling. Unless there's any questions, that's all for today.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
You're welcome. I'll have the order for you in a few minutes. All right, we are on record for a review and permanency planning hearing this morning. May I have the names of our participants, please?
Alexis Stang.
Nicole Underwood, lawyer guardian ad litem.
Ms. Tasha Thomas, counsel for the department. Ms. McVeigh.
McVeigh from the department.
You want me to unfair Judge Sala?
You've been released from jurisdiction, so you don't need to. You're okay.
Alexis Stang on behalf of Joshua Esterline. Can you say your name?
Joshua Esterline.
All right, Ms. Underwood, let's go to you first for your report.
Thank you, Your Honor. I was able to meet with a minor child at his mom's new residence. It was refreshing to see that they have moved into a new place that has more space. There's a garden. The child was showing me he showed me his room and his space, and
again, all of the vegetables and fruits that they have planted in their yard. He seems to be very happy and comfortable at mom's. The school year ended, so they're just getting into the swing of summer, but all of his needs are being met at his placement. I know he's going back and forth between moms and dads, but it's my understanding there was a little period of time where Mr. Esterline was moving and securing some new housing. So it's been a little while since he was there, but I believe if all went as planned, he may have gone to visit dad yesterday. But again, this case is going very well. I'm happy to see that mom is thriving and doing well. Dad seems to be getting on his feet despite all the additional challenges that he's facing in a unrelated case to this. But I'm happy to see that, again, the child's needs are being met. He continues to be with his parents, which is the least restrictive environment. And his best interest would be to remain in his parents' custody. Thank you.
Right, Ms. Thomas, testimony today.
Thank you, and I'll call Ms. McVeigh to provide her report.
All right, Deputy Ames, if you could swear in Ms. Megan McVeigh. Yeah. Go ahead, Ms. Thomas.
Thank you, Your Honor. Ms. McVeigh, you've provided a court report for today's hearing. Inclusive of the court report is the case service plan for dad, my family prevention plan, and then a letter from the child's therapist. Are there any other documents that you've circulated or filed since the submission of this court packet?
No, there's not.
And are there any updates or modifications that need to be made to the court report or any of its documents?
No.
Okay. And at this time, the child remains with both parents. Is that correct?
Yes.
And generally speaking, how would you describe dad's level of compliance with and benefit from his case service plan?
He's been doing really well. He participated in the My Family Together program and was able to successfully complete that. And services ended early. And because of his success, he has obtained housing. He has obtained a full-time job. And he's in a really good place right now.
And related to the, I guess, the job component here, is there any concern for childcare during working hours, or has that also been accomplished with dad?
He has childcare. His brother was watching the children the last I checked, so. And they have a relationship with him.
Wonderful. And I noticed in the report there was a complaint called in regarding dad and the child, and it was closed out. Is there any information you'd like to provide the court regarding that incident or your determination to close out that investigation?
I did not do the investigation. It was assigned to an investigating worker, but it was found, it was denied, and that there was not a preponderance of evidence.
Okay. And generally speaking, do you believe that dad and the child are doing well?
Yes.
And are there any other services that the department or the court may be able to help them with?
I don't believe so.
And at this time, is there any need to continue jurisdiction for the family as it relates to dad and the child?
I don't believe so. He's been doing really well. He's in a really good place right now.
Okay. And are there any services that would end if jurisdiction was terminated?
All the services have already ended.
Okay. And is there anything else from your knowledge of the case or your report that you would like to highlight for the court today?
I don't believe so. Just that he's doing really well, and I'm really proud of him.
Wonderful. Thank you so much. Your Honor, I have no further questions of Ms. McVeigh and would move to admit the court report.
Objections?
No objections.
Thank you, they are received. Questions for this witness?
I have no questions. Thank you.
Okay. Ms. Underwood, any questions?
No questions.
All right. Any additional witnesses, Ms. Thomas?
No, Your Honor.
Anyone you'd like us to hear from today?
No, thank you.
Ms. Underwood, any witnesses?
No, Your Honor.
Very good. All right. What's happening with the custody for Mr. Esterline? Do we have copies of that in the file? I did the order, but it's.
And are you
Ms.
referring to the subject minor or the children not subject to the NA case?
Oh. Okay, that would be the other child. Right?
In the case not involving the NA case, there are 2 minor children.
Right, no, is the child that's subject to the court hearing today, is that Daisy's child?
No.
Okay, all right. Never mind, everything's fine. Okay. Ms. Daisy Brown has joined us today. Ms. McVeigh, have you had any interactions with her over the course of the last report period? Is there any updates you wanted to give us on that piece?
No, Miss Brown lives in Ohio. She is not receiving services from the department.
Okay. Right. All right. Anything else then before we close?
No, Your Honor.
No, thank you.
Ms. Underwood?
No, Your Honor, thank you.
All right. While the court finds all interested parties were given notice for purposes of today's review and permanency planning hearing, it does appear that the goals of reunification have been accomplished. Congratulations to Mr. Esterline for really pulling all the pieces in together and stepping up for both for yourself and for your children. So I will grant the request to release the family from the jurisdiction of the court and close the case effective today. Thank you again to all of the efforts given by Ms. McVeigh and our guardian ad litem. But I will grant the request and release the family. Congratulations.